All right, good morning, students of the Western Pacific University, and welcome back to another segment of these lectures. We have covered the last 2 weeks. We've covered topics of introduction to the PNG legal system, and last week we briefly looked at property law in Papua New Guinea, and now we're going to look at the law of contracts in Papua New Guinea. So, with the law of contract, it's a very, very huge subject in law. Normally, when we teach it in Australia and in Papua New Guinea, we divide the course into two components. We teach it as the law of contracts 1 and the law of contracts 2. That means that there's so much, the substantial amount of legal doctrines in the law of contract. That's why we had to, break it up. But for your case, it's just a topic in the economic law subject, and I will try my best to sort of examine the topic, or I've tried my best to examine the topic and flag out important points that would be of value to you and to this course. And I will only teach the general, valuable components of the course. In that way, it will give you a basic understanding of the essential elements of the law of contract. So please bear with me. If you need further questions, further queries, send me an email, get me on WhatsApp. If you need some discussions, some consultations, or if you can get me on WhatsApp, or if you want a video call, if you want a mobile call on WhatsApp, or if you want to jump on Zoom or Microsoft Teams, more than able to talk with you one-on-one, or be of any assistance if I can. Alright, so a little bit of description about the course. If you look at your slide number 2, it says that contract law examines the nature and preconditions of contractual liability. So contract law talks about the nature of contracting. What is the essential nature of contracting? This includes the study of the requirements of the formation of a contract. So that when it says the requirements of the formation of a contract, it means that what are the essential elements that need to be present for a contract to be duly formed. Secondly, it looks at the law's approach to terms that compromise a contract, and thirdly, the various ways in which a contract might be discharged. So the law's approach to terms that comprise a contract, that means that what are the terms? What are the terms of a contract, and what are the way in which the law categorizes those terms? And secondly and thirdly, it looks at what are the ways in which you can discharge a contract, either through performance, either through breach, either through repudiation. What are the ways in which a contract can be discharged? Alright, for further reading, there's some really good books on the law of contracts. Jesse and Pfeiffer is a classic. Femstone is a classic as well. Pedersen Robert is a really modern book on the law of contracts. So if you want a further sort of understanding or further build your knowledge on law of contracts, see if your library has a copy of these very important books. Alright, so I'll give you an outline of what we sort of cover in this course. So we look at all these important contract theories. We look at the idea of contract, place of contract, and topics to be covered. Alright, the idea of contract. An agreement or a set of promises that the law will enforce, or for breach of which the law will provide a remedy. That's the basic idea of a contract. An agreement or set of promises that the law will enforce, or for breach of which the law will provide a remedy. A contract can be written in writing, for instance, employment contracts, conveyancing, buying and selling property contracts, or it can be oral contracts. Someone rocks up to you and says, "Hey buddy, what's up? Can you give me like 50 kina? And next week Friday I'll pay you 75 kina. I'll put 25 kina profit add-on." So that's what you call an oral contract, which is by word of mouth. There's no paper, there's no documentation about it, and basically you do it orally or by word of mouth. Alright, so when you talk about an agreement, set of promises, people or parties must agree. And what happens if they agree is that they create a legal agreement or set of promises. So let's look at this example. So I, Dr. Pumuye, am selling my Toyota 5-door for 100,000 kina. And Peter comes along and wants to buy that Toyota 5-door. So I'm offering or selling my Toyota 5-door for 100,000 kina. That's my offer I'm making. When Peter as the buyer comes along and accepts it, Peter will say, I accept your offer, and Peter will give me 100,000 kina. In the event that he gives me 100,000 kina and I don't give him the 5-door, I'm in breach of the contract. So the law will enforce the contract. The law will basically tell me, give the 5-door to Peter. That's the law enforcing the contract, because I have breached the contract. Or if I can't give the 5-door to Peter, the law will say, or will provide Peter a remedy, because he is the party that has suffered from the contract. So the remedy will be saying that, all right, Dr. Pumuye, pay Peter back the 100,000 kina. So that's what the statement means, that it will enforce a contract or it will provide a remedy for the innocent party. All right, the historical development of the law of contract. Before, human societies were hunters and gatherers. They moved from place to place, did not settle down, and until it came to a point in time where people started settling down in one location, building villages, communities, civilizations, empires, kingdoms. So when people congregated together and lived together, they sort of embarked on a lot of trading of goods and services, a lot of relationships where, if you provide me with fish, I will provide you with sweet potato or taro. Or if you come and help me make my garden, I will help you build your house. So these type of contractual relationships basically thrived when people started living in societies. They would have a relationship within their own communities and also with neighboring villages and communities. Because there was an increase in commercial transactions and relationships, there was a sort of like a need for a set of rules to govern the basic rules of contracts or transactions, and also to provide some remedies if there was some disputes in these little transactions. So these sort of notions and practices gave rise to the law of contracts, and then it was championed by the common law. And the United Kingdom, when they developed the common law, so most of the fundamental doctrines of contract law is derived from common law. And from common law, you have legislation, laws passed by Parliament, and you have case law, laws, cases decided by judges. So case precedents, a judge that's made a decision has been applied to a period of time, which becomes a precedent, and these precedents provide essential doctrines of contract law. So most of the essential doctrines of contract law, they are provided by case precedents. So the question now is that, how did all this contract law and case precedents come to Papua New Guinea? Remember, in our earlier lectures, we were looking at the hierarchy of laws under Section 9. We said that the underlying law, as a source of law in Papua New Guinea, adopted the common law and equity of the people of England and the customs of Papua New Guinea. So through that underlying law, we adopted the common law and we adopted all these contractual principles. Just the basic of the law of contracts. Now the place of the law of contracts in the legal structure. If you look at slide number 7, I've given you a diagram there. So law is a generic term. Then you have national and international law. So international law would be laws such as the United Nations Convention on Human Rights, or United Nations Convention of Rights of Children, or International UN Convention on Labor Law. These are all international laws. The national laws would be our national laws that apply in our country in Papua New Guinea. And then the national law is divided into another category, which is public and then private law. Public law would be laws like constitutional law, criminal law. These are laws that deal with public bodies and the public. And private laws basically deals with private parties and persons in a one-on-one sort of context. So private law would be something like law of torts, law of contracts. All these come under the branch of private law. Alright, just to re-emphasize the point of laws, laws can be laws passed by Parliament or the common law under judge-made laws, so we call them case precedents. So in the common law days, the King's Court basically developed the principles of common law, and the law of equity was developed by the Chancellor's Court. This is a historical sort of background to case precedents as a source of law. Alright, we look at topics covered in this subject, and then we look more into the essential elements of a contract. So when you look at your slides, you would see that I've divided this into three sort of major headings under the law of contract. We look at the formation of the contract, what are the essential elements that need to be present in terms of the formation of the contract. Then we look at what are the terms of the contract itself, and then we look at performance and discharge of a contract. Alright, what is a contract? A contract is an agreement or a set of promises. The law will enforce, or for breach of contract, it will provide a remedy. That's the basic sort of understanding as to what is a contract. If you look at slide 12, it says that the essential elements of a contract. There must be offer, there must be acceptance, there must be sufficiency to complete the contract, there must be intention to create or enter into a legal relationship, and there must be consideration. Alright, offer, acceptance, and consideration. These are the first three topics that we'll be covering. In this lecture, I will cover the topic of offer, but I would like to give you a basic background of what is an offer, what is an acceptance, what is consideration, what is intention to create a legal relationship, and what is capacity. Alright, offer. Offer is basically in a contract is the fact that is an expression by one party to the other party. So when you look at an offer, an example would be, like I said, me selling my Toyota 5-door for 100,000 kina. I'm making that offer. If someone comes along and accepts it and says that I'm willing to pay the 100,000 kina, I accept your offer. That is acceptance. There must be offer, there must be acceptance. Now, consideration. Consideration in law is basically the price for the promise. To validate the contract, parties must lose something and gain something. So that's what you call consideration. You must provide consideration for the contract that you entered into. In my example, my consideration in the contract is giving my car away. It's the price I pay for the promise of 100,000 kina. And the person buying my car, let's say Joe for instance, the price Joe pays is the 100,000 kina to get the car. So that's what you mean by consideration.